But I'm more concerned here is the matters that led to the subdivision, the nature of the subdivision, 5?
Well, no, I guess it was not approved until 2007, late in 2007, but it was, the coastal subdivision number was 12/2005, and it took approximately 2 years to wrap up that subdivision. One of the reasons why is because it was originally submitted as just a subdivision, and there was some concern about what kind of structure would be built out there in a designated highly scenic area on the west side of the highway. And again, to preempt the unknown possibility of some unacceptable development being proposed there, I advised the property owner to go with a coastal development permit embedded in that subdivision. And so that subdivision was actually brought over to our coastal office, and I was the project coordinator on that. And we had Mr. Patrick go to the drawing board and design an actual structure so that we knew how tall it would be, what color it would be, where it would be, and that we had all the natural resources protected. And that made the project more viable and less unknown and less uncertainty, so that the project wouldn't get appealed by the California Coastal Commission or other concerned citizens in the neighborhood who had stated that they were worried about protection of natural resources and the specter of having a second home on the west side of the highway in a highly scenic area. So to address all those issues up front, we had Mr. Patrick propose an actual development project for the proposed subdivision, and it was approved as part of one package. And so there was a coastal development minor subdivision and a CDP 67/2006, and technically there was also a use permit associated with it because the property has planned development combining district, basically because of the sensitive and unique nature of the site. And so what we have now is a complete picture of what we're going to have on the 12.5 acres. And the complete picture is done. What I guess to clarify, the access easement that's being utilized today, that we're discussing today, was part of the original subdivision from 1985 by the California Coastal Commission. The second easement that may be confusing you now was part of the County Planning Commission's approval of the subdivision most recently, and it is only it's a small, skinny, I don't know if it's 20 feet wide, 15-foot wide strip of land immediately adjacent to the white stripe of the highway on the west side of the highway. And that is just there, hanging out there for potential pickup in the future if the coastal trail up and down the coast gets realized adjacent to the highway. But it is not being utilized in any fashion for this project. This project is completely contained in the original easements that the Coastal Commission exacted from the previous property owner in 1985.
Okay, that's helpful. My concern is I don't want to have to revisit this when changes hands and the individuals want to say, well, we bought it knowing this, but now we want this or that in the way of a compensation on this. I do not think it's appropriate. I guess it's entirely allowed for the land trust to pay insurance on this, but I don't know that it should be the county. I don't believe here should be in a position of validating that particular response. I think it should be private transaction between the land trust and the property owner, because I think it does set a standard here that we are going to be looking at if we were to be talking about other coastal access opportunities. I would characterize it as a gift of public funds if we were to endorse it. The land trust can do whatever it wants with the property owner once we accept or reject, if we reject the appeal, and then whatever accommodation they feel they need to make. I'd ask the county council for just a comment on that.
You're talking about the insurance issue?
Yes.
Yeah, well, it already appears that they've offered that up, and that really would be between the landowner
Okay.
and the trust. You're right
Okay.
about that. But it's clear that they've already offered that up, so that's something that the two of you should be working out.
Supervisor Pinches.
My question is along that. First of all, the Mendocino Land Trust has offered up
to indemnify Mr. Patrick. But I really feel it should be in the condition, because that's really, but it shouldn't be with Mr. Patrick, it should be whoever owns a piece of property, because this is an easement, but the land that's actually owned under the easement will be the property owner, whether it's Mr. Patrick or if in 2 years he sells it. So the agreement should, or the conditions for approval should state that the Mendocino Land Trust will indemnify the owner of record for their easement. That's my opinion of how it should. I'm not an attorney, but
Well,
it
my-
shouldn't be against, the agreement shouldn't be against the property owner, because that way, if Mr. Patrick sold a piece of property, it should be with whoever holds title to that land, whether it's Mr. Patrick now or in 6 months he sells it to somebody, because the easement's going to stay there probably forever. So the indemnification should be whoever the present owner of record is.
Right, but my only concern is that really the indemnification issues and the liability issues are between the land trust, the state, and the property owner. It's not really within the county's purview, and if you start attaching conditions like that to these permits, you're going to set precedent that you may not want to set, and and then you'll end up being enmeshed in this kind of, in the litigation aspect.
well-
So my feeling is that they've already represented that they're willing to go ahead and negotiate with the property owner to do, add them on as an additional named insured, and that should be sufficient, and then that can be worked out whenever the property's sold with the next owner.
I tend to disagree a little bit. First of all, it's nothing new for this county to put special conditions of just about everything and anything on any type of development. So to do this would be nothing new, and it wouldn't set a precedent. There's no such thing in government where you're setting a precedent. You as attorney understand that. So I just feel that, this is a condition that the land trust has agreed to. So why don't we solidify it by putting it in writing?
I'm not
make it
saying that
with-
you can't do it, I'm just saying that you have to be cautious about setting this type of precedent where, from this point forward, folks are going to be coming in and saying, you did it once, why aren't you doing it for us?
Well,
When it's really not within your purview to be having to, for you to be worrying about the insurance and the indemnification provisions. That's all I'm saying.
It isn't, but and I've never reviewed every easement that the Mendocino Land Trust has or other conservation agencies have. But I think there is a real liability issue here, and when you basically put a advertised trail that says, hey, head out here to the end of the bluff, and by the way, you got to stop there, but if you go over, well, then you might have a problem with the owner, and so I think there's a special circumstance here where, the private property right, they have rights too, and I understand their right to want to protect, he bought the property for future benefit, he never bought it for future going to court. So I think there's a legitimate case here and the land trust has actually offered up that they'll identify. So I just think that we should put that as a condition and solidify it. And I don't think it's setting a precedent to do anything.
No. I'm going to continue with a couple questions, Mr. Bernard, sorry. Supervisor Smith.
Thank you. Well, it seems to me